Now look at this news article about habitual offenders. Now currently habitual offenders is in news because last year itself Supreme Court has asked the states to reconsider the implementation of Habitual Offenders Act. But currently, as per Lok Sabha's data, nearly 14 states have are implementing these laws even today. So from the mains perspective, we have to learn about the basics about these habitual offenders, and we have to learn why these states are even today implementing these acts. So we shall start with who are habitual offenders. Before that, you have to learn about the syllabus under which this particular topic falls. So it will be coming under both governance as well as social justice. So under governance, the reforms part of this will be asked as a question, and when it comes to the social justice part, the people who have been oppressed for a so long period of time, even they should get rights. So those kinds of things will be asked under social justice. So we shall see who are these habitual offenders. So habitual offenders are people who are repeatedly convicted of crimes. So when we take about the talk about the NCRB data, literally 1.9 percentage of 1.29 lakh convicts has been classified as habitual offenders, and it is highest in Delhi, which is 21.5 percentage. So you can use all the data in your mains answer writing. Now, talking about the origin of the habitual offenders law, it has the colonial backup. When we take 1793 regulation. So when we take 1793, Regulation 22 has empowered the magistrate to imprison communities based on suspicion. So this is the actual exact origin of this habitual offenders law. In 1860 to 1861, that is the time when the IPC was actually framed. During the framing of IPC as well as CRPC, they had a separate section for dacoits and thugs. In 1871, the Criminal Tribes Act, in short called as CTA, was introduced. This term introduced the term criminal tribe, and based on this only, in 1924, the criminal tribes has been identified across colonial India, and it has expanded the criminalization of communities. Now, moving on, after the post-independence, we had certain developments. In 1952, we actually repealed the CTA, which is nothing but the Criminal Tribe Act, which identifies the communities who are habitually offenders, and this has been reclassified as denotified tribes, nomadic tribes, as well as semi-nomadic tribes. Then when we talk about state laws, certain states even today they are implementing these habitual offenders law. In 1948, Madras Restriction of Habitual Offenders Act, it even extended to Delhi, 1951, and in 1953 to 1970 similar laws has been adopted in Rajasthan, Andhra Pradesh, West Bengal, Karnataka, Goa, and etc. Moving on, we shall see how habitual offenders are defined in states. See, crime, the people who does the crime, being a thug, a gang involvement, and earning from prostitution and luring offences, they are classified under this particular habitual offenders in states. And based on these classification, they have even developed a procedural mechanism, and certain states they maintain registry, and even in jail manuals they include habitual offenders, and some states they designate erstwhile criminal tribes members as habitual offenders. A very good example for this is Rajasthan. Then we shall see what is the legal status across India. Certain states are supporting it and certain states are not supporting it. When we talk about the supporting states, we have Gujarat. They claim law does not target any community, but it is there for safety. And the Uttar Pradesh, they are telling that it covers under UP control of Gundas Act 1970. If you know what is this Gundas Act, you can leave that in the comment section. When we talk about Goa, there is no denotified tribe, nomadic tribe, as well as semi-nomadic tribe. Hence, there is no need to repeal in that particular state. When we talk about the opposing states, there are Punjab, Andhra Pradesh, Telangana. Law is these states tell that these laws are not required for the states, and 9 states they have never enacted or repealed this particular Habitual Offenders Act. Now moving on, we shall see about the legal challenges as well as Supreme Court's view. Supreme Court has already said to revisit the definition as well as the act to different states. However, even today the states, literally 14 different states are upholding this particular act, and that is why it made news today. Now we have to see what can be done. we have to first review the relevance of the act. So the states, they should assess the necessity of the act in the first place. Secondly, they have to bring fair legislation. This should avoid stigmatization of communities. Thirdly, we have to bring in lot of empowerment programs. So when people are brought with empowerment by giving upskilling things, so they will be focusing on rehabilitation and reintegration instead of going to crime. And we have to bring in lot of sensitization, even police training to prevent biases should be brought in, and this can be done through capacity building as well as training. So we can tell that habitual offenders law is even today contested, and the balance, we have to balance the security with human rights, and we have to repeal or reform is necessary for justice as well as inclusion, and for that we have to for sure take a step. And based on this discussion, we have framed a Bain's practice question for you. Let me read out the question. Do habitual offenders law in India uphold justice or reinforce systematic discrimination? Critically analyze. So you have to give both the positives and negatives of it, and you have to analyze both the positives as well as negatives, and you have to suggest a way forward. So this is actually a 10 marker question, and you have to write answer for 150 words. You can write an answer and post it in the comment section so that we can review your answer.